I don't have any other questions, Your Honor.
All right, thank you. See everyone at the bench. You all need a break before redirect, or are you good? You good?
Yes, I do, Judge.
Go ahead, Mr. Lenneman, redirect.
Yes.
Hold on, let me turn the mic up. Go ahead. Thanks.
It's too much. I don't. You sure?
Let's talk about what you reviewed in this case. Specifically to Dr. Mayer.
Yes.
You were provided, I guess, his deposition?
Yes.
Okay. That is the deposition from Miss Dixon's murder. Is that correct?
Yes.
You were provided videotape because the actual trial was videotaped. Oh, thank you. You were provided actual videotape of the trial.
That's correct.
Where these experts testified.
Yes.
You may have been provided a report, but that had to do with Dixon.
That's correct.
Right?
Yes. That was the Dixon case.
Isn't it true you were never provided anything from Dr. Mayer that he gave opinions on the sanity or insanity in this case?
That's correct.
So when Mr. Williams was up here pontificating about Dr. Mayer's testimony and your knowledge of that, that was an untruth.
Yes.
Now I want to talk about your opinion on the death penalty. The state asked you a question that you were against the death penalty.
Yes.
Tell the jury why.
Because I question the equity of the process, that it is applied equally to all persons.
Judge, I had a juror raising their hand.
I'm sorry, yes, sir. Yeah, he can't hear you.
Okay.
Go ahead. Thank you.
I said that it's because with respect to the fact that it is not applied equitably across all individuals.
And are you referring to blacks?
I'm referring to blacks. I'm referring to anyone oftentimes without sufficient money or finances.
Now, Mr. Williams was talking to you about the DSM-5 and the issue of you not following the DSM-5's checklist. You remember that?
Yes.
Okay. And you tried to tell him that there were other things that you relied on.
Yes.
Something very well known around the country and used by, especially by trauma experts.
Yes.
And that's called the adverse childhood experience.
Sustained.
Okay. What is it that you used in terms of trauma besides the DSM-4 to evaluate my client?
We have a scale that we use to gauge adverse experiences prior through age 18. That is one thing. The other thing that we use is there's numerous work that has been done, findings that have been published, that have been accepted for over 15, 20 years. And that particular research.
Objection. Sustained.
Judge, I believe that this door was opened.
It was not. You may sustained.
My final question is that Mr. Williams went back and forth and on about this issue of my client's thought that the police were trying to kill him. Remember that?
Yes.
He's been around police officers. He was certainly around Lieutenant Clayton in the Walmart. He's been stopped by police officers. He's interacted in police officers. And even though he, in his mind, believed that the police were out to kill him, the police were going to kill him. Mm-hmm. Is that right?
Yes.
Okay. So would you agree with me, the circumstance, hypothetically, of a man running away with his back to someone who hears a shot would believe that they are shooting at him?
Yes.
Is that a different circumstance than just interacting with people?
Yes.
Nothing further, Judge.
All right, thank you. May this witness be excused. Mr. Lenneman?
Yes.
Mr. Williams?
Yes, Your Honor.
All right. Thank you very much, Doctor. You are free to go.
Thank you, Judge.
All right, ladies and gentlemen, that was our last witness for today. As I said, we needed to go a little bit late. Apologize for that, but we're on track, and that's what we needed to stay. Send you back to the hotel. We are not working tomorrow. I hope you all have a very relaxing and nice Sunday. The weather's supposed to be beautiful tomorrow. That's what I was told. And I will see you Monday morning at 9:30. We are on track to finish this case on time. All right, thank you. Anything further from state?
No, Your Honor.
Anything further from defense?
Yes, Judge.
What's up?
I have some significant concern that I've heard that the only way the jurors are going to be able to view these electronic exhibits is in this courtroom. I think that's absolutely an infringement on their ability to interact. There are some lengthy videos that they have to view, and I want to try to find a way to allow them to view these things in the back.
There's a wiped laptop that's used.
So that's going to be used?
Yeah, there's a wiped laptop that's
Okay,
used.
okay.
All right,
Yeah,
anything
one more
else?
thing, Judge. I talked to both of your, both of the AV guys this morning and this afternoon, and they indicated to me, obviously, what I just said, that it would have to be done out here. The reason I was talking to them is that there is a particular code which is very simple that has to be put on that computer to allow them to look at my drive.
What computer? I don't own the computer. State Attorney's Office owns the computer.
No. I'm talking about the
about?
laptop that would go back there for them to view this stuff.
Yeah, that's not my computer. That computer, it's not the court's computer. That's a computer the State Attorney's Office uses that's been wiped. Everybody checks it to make sure there's nothing on it except the ability to play videos.
Well,
So I don't have control of that computer.
I need to check, obviously, before we
Yep.
get to closings.
Okay? I expect them to be Tuesday.
Okay?
So I suggest you guys get together and get that done. All right? Anything else?
No.
All right. Have a good Sunday, everyone. Court's in recess.